Holmes versus Nakia Bennett. Mr. Bennett, I do need you to unmute and turn on your camera.
Hello?
Yes, Mr. Bennett.
Yes, ma'am.
Yes, can you turn on your camera? Do you need me to send you a prompt? Here, I'll send. Hold on, I'll send you a prompt. There you go, Mr. Bennett. I see you now. All right, Mr. Bennett, I'm going to have you raise your right hand.
Why I raise my right hand?
Because you're going to, anything you say has to be under oath. You have to swear to it.
Now, I got to say this. That's against, like, my religion. I'm going to tell you the truth, though.
Well, I just want you to swear to tell me the truth. You're not going to tell me the truth?
I'm going to do the best I can.
Well, no, there's no best. It's either the truth or it's not the truth. Are you going to tell me the truth or no?
I told him to tell you. I got you.
No. You got to, are you going to tell me the truth?
Yes.
All right. Thank you. All right. So now we're going to have a hearing on your case because my understanding you and the attorney weren't able to reach an agreement. Is that correct?
I can't hear you.
I'm going to have a hearing on your case and make a decision.
Okay.
Okay. I'm going to hear from the landlord's attorney first because they filed it. So they have, they go first. Once they're done speaking, I'll hear from you. Okay.
Okay.
All right. All right, Mr. Bolden, I'll hear from you.
Hi, Your Honor. Thank you. As I mentioned before, this complaint was filed seeking possession only. We're not requesting monetary damages. Mr. Bennett is an unauthorized occupant at the subject dispossessory premises at 24. Plaintiff has tendered the recorded deed as of December the 14th, 2023. We asked the court to take judicial notice of the deed. And as the court can see, we would move to admit that as Exhibit A. It is filed into the record of this case. And that my client, Vinebrook Holmes, is the owner of the subject real property at 2499 Tolliver Drive. If I could direct the court's attention to page 2 in the deed, it's going to actually probably be page 7 in total. There in the property list, the schedule, you'll see item 44 lists the subject real property.
Okay.
And then it's also referenced on page 35 of 83, labeled therein as Exhibit A-44. And you'll see there, there it is again. That's correct. Jurisdiction is proper, as you'll see, it is in DeKalb County. And so therefore we are asking for possession in 7 days. I'll also mention this is not my first run-in with Mr. Bennett. We had a case together last summer in DeKalb for another client's property.
On a different piece of property?
Different piece of property, yes, ma'am.
All right, Mr. Bennett. What would you like to tell me?
I don't know this man. So what they want from me? Money? Oh.
No, they don't want any money. They just want possession of the property. Basically the exhibit that I have on the screen, I think you all can see it. Let me go back.
Okay, look.
That shows that they are now owners of the property, and so they want possession.
Okay, but it's rights to this, right? I got a lease, a legit lease from Vinebrook. You know, I paid money, all that. We can't come to no agreement. I don't know. Maybe I need to see you in person to present my evidence like he presented here. You know what I'm saying?
Well, Here's the situation. Once they show me this deed, can't go behind the deed. It says that
I have rights to be in this house because I spent money. I got a lease, and I didn't criminal trespass or nothing. I was able to come in.
guess is Mr. Bolden's going to say they don't have a lease with you.
Who don't have a lease?
That's
Vinebrook.
correct.
I don't know why. I don't know why. Did you read the police report?
Do you have anything else you want to tell me about Mr. Bennett?
I said, did you see the police report?
Oh, you're talking to me. Was there a police report that you wanted me to look at?
Yeah.
What was that police report?
The police report. It should have been a police report. The police came out here for these people, telling me I'm here illegally, and I'm like, it can't be illegally. How am I here illegally? I have my lease. I have proof. You know, like I understand he got a deed that's on the same thing that I'm telling you. He's showing you a deed. I'm showing you a lease. You know.
No, you're not showing me a lease. I haven't seen a lease.
I mean, I can send it to you. Same thing he did. You know.
Go ahead.
All right, I'm going to get it out my email. Give me a little time. Come back at me, please.
You need the email address to send it to.
I know.
Do you have that email address?
I'm finna get it out my email for you right now. I mean, I'm finna go to it. I didn't know. I thought it was like a hearing.
Are you going to email it?
I didn't know I had to present these things. I thought this was like, I didn't know it was going to be like this, you know.
Right. So you can email it to me.
Okay. I'm getting it for you.
Okay. Do you have the email address?
No, I don't.
All right. So if you go to the chat here in what email are they sending it to, Ms. Hart?
You can send it to mine. I just sent him my email address.
Okay. You should have an email address where you can now send it to.
Okay. I'm getting it now for you.
Okay.
Give me,
and then I will.
A little time.
I'm sorry?
Can I have a little time?
Yeah, go ahead.
Okay. Okay.
And I'll put it up the same way that I put the other information up.
Okay. So the attorney and the judge watching it right now?
Yes, sir.
That's lame. She gonna look at it with the attorney. She about to look at it with all of it. That's not my attorney. How she gonna do that?
Mr. Bennett.
Yes, ma'am.
We're back on the record.
Hey, can I ask you something? How you gonna present it without me being present?
How do you know I presented it? Mr. Bennett, I have not presented anything without you present.
Thank you.
To assume things is completely inappropriate. I have received the document. Mr. Bolden, who should have seen it before, has not had an opportunity to see it yet. Mr. Bolden is now going to look at it when I post it or present it or publish it for the first time. You need to be on camera, Mr. Bennett, so we can have this.
Oh, I see. It say start video. Okay. Okay. Can you see me?
I can see you.
Okay. Thank you.
Mr. Bolden, do you see the document on your screen called residential lease agreement?
Yeah, I don't dispute that he's got a lease, but he's not in privity of contract with my client. My client's lease, I can attest, does not look like this. It would be DocuSign between the parties.
All right, Mr. Bennett, is this the document that you submitted to the court?
Yes, indeed.
All right. Is there any specific portion of this document that you would like me to look at specifically?
Vinebrook and Vinebrook, how much I paid, the legitimacy of it, you know, my signature, their signature, you know, the authenticity of it. You really can look at all the pages if you want to. They there.
Who's Jamie Parker?
That's who sent it to me, and I sent her all the cash at one time.
right.
That's who sent it to me, and I docu-signed it. I think
Well, that's not a
And
DocuSign.
I think
ask
that
the
is
other
telling.
And only one person
ask
can
the other
speak at a
party
time.
who is Jamie. They know who Jamie is. Ask them who Jamie Park is.
Mr. Bennett,
Yes, ma'am.
you may have an agreement with someone named Jamie Parker, but Weinberg Homes does not know a Jamie Parker. Maybe they scammed you. But
Can I ask-
according to Weinberg Homes, they do not have a lease with you.
Okay,
This
I
is not
heard
their lease agreement.
maybe he was a party that worked for them, or she was a
Maybe.
party that worked for
But
them.
I
I don't know. I don't know. You had to ask Vinebrook who did they know these people? These
Mr.
people.
Bolden just testified he doesn't know this is not a Weinberg Homes lease agreement.
That's correct.
I don't know.
And towards that end, his testimony regarding the method of payment, cash would not be an acceptable method of payment.
All right, anything further from either side?
Yes, Your Honor. What is the amount of rent that is set forth in the lease?
This lease right here?
Yes.
Are you still seeing the screen?
Yes, ma'am.
My phone is about to go dead. Oh my God.
All right, well, I better make my ruling then. I do find then.
Well, Your Honor, before you do that, I would like, if the court does find in favor of the plaintiff, I would ask that
Hey, I can see a
the court utilize the $1,900 set forth in the proffered lease in the court's order regarding in the event a petition for review is filed, that $1,900 is paid in the court registry each month.
All right,
Pursuant to
Why you want me to do that?
44-7.
Why you want me to do that if he stayed in my lease?
Mr. Bennett,
And he don't want no money
not
from me.
interrupt,
Okay.
not interrupt. Mr. Bolden,
That's
anything
all.
further?
That's all I have, Your Honor.
All right, Mr. Bennett, your opportunity for your final statement.
First, when he sweared in, I didn't see him swear in, but you know,
He's an officer of the court. He's been sworn in whenever he became an attorney.
Well, he been lying because he showed it to tell me
Oh,
he didn't want no money from me, and he told you that he wanted possession. So I'm confused at this point. You know,
I can explain that.
I'm confused.
Is there anything further?
And
Okay, I can explain that. Is there anything further though additional?
I want you to explain it so I can get a better understanding.
I will. Well, I'll explain it to you when I'm making my ruling. All right. So based on the evidence presented, this is my turn to speak, so please no interruptions.
Okay.
I do find that the Weinberg Homes is entitled to a writ of possession. I will grant them a writ of possession 7 days from today's date. Today is May 5th, 6, 7, 8, 9, 10, 11, 12. That is May 12 at 11:59 p.m. Now, Mr. Bennett, you do have the right to appeal, which is called a petition for review within 7 days. I'm not done speaking.
Oh, I'm sorry.
You do have a right to appeal within 7 days from today's date, which is called a petition for review. Now, one of the requirements for filing the petition for review, if you are going to be on that property, is that you pay rent into the court registry. Since you are allegedly already paying rent in the amount of $1,900 a month, that will be the monthly rent that you will have to pay to the court during the pendency of your appeal. That is by Georgia law. So that will be $1,900 a month. If you choose to appeal, you can appeal to either the state or superior court of DeKalb County. The exact location where to make that appeal and where to make the payments will be on the order that you receive from the court. I've finished making my decision. Mr. Bolden, do you have any questions?
Nothing further, Your Honor.
All right, Mr. Bennett, do you have any questions that you need to address with the court?
Yes.
Go ahead.
How can I take it to trial?
Just had your hearing. You have, as I told you, you have a right to appeal within 7 days from today's date. And
So
all the
what
concerns you have can be in your petition for review.
and I want you to know this. I know King Solomon and I know Queen Sheba. But look, I'm gonna also say this to say that so basically what was wrong? Am I guilty or why I gotta pay
Well,
over? Why I
guilty,
gotta
no,
pay
it's not a criminal case.
and on bank
Just I found in favor of the landlord.
and I feel like I really needed a lawyer because I'm filing for bankruptcy behind all this. It's a lot.
Go speak with an attorney then.
And I just feel like you weren't good enough for me. I wish I could have had a whole nother lawyer. I mean, a whole nother judge, because clearly you weren't hearing me out at all. You really weren't no good at all. It's like what I said didn't matter. It's just your attitude just stank so bad. You know what I'm talking about? Yeah. But
well, that is the decision of the court, Mr. Bennett.
I appeal it
You're
through
hearing
superior today. You know what I'm saying? And I don't want you to be my judge no more because you just ain't no.
All right. Thank you, Mr. Bolden. You're excused. The order
Thank you,
will
Your
come
Honor.
to you in your
Thank you,
email.
Madam Clerk. Have a good day, everybody. Thank you.
Thank you.
What you just witnessed wasn't a screaming match, a thrown punch, or a single explosive moment. It was something far more uncomfortable and far more realistic. This was a slow burn neighbour dispute, where ego, pride, and assumptions quietly escalated into a courtroom showdown that nobody truly won. At the centre of it all was something deceptively small: a loud truck, a single text message, and a refusal to acknowledge the other side's concern. And from there, everything spiraled. The judge immediately framed this case for what it was supposed to be: an anti-harassment hearing, not a criminal trial, not a morality contest, and certainly not a neighbourhood popularity vote. Ground rules were laid out clearly: speak one at a time, direct everything to the court, and explain why legal protection was necessary. Simple enough. But as soon as testimony began, it became obvious this wasn't about one incident. This was about perception, resentment, and control. Wyatt Johnson came in asking for one thing: to be left alone. On paper, that sounds reasonable. But the court doesn't operate on vibes or intentions. It operates on conduct. And the judge wasn't confused by what Wyatt said he wanted. He was confused by what Wyatt did. If you don't want contact, why repeatedly drive past the same house in a way that multiple neighbours describe as provocative? That disconnect is where this case immediately started to wobble. Then came the definition that matters most in these hearings: harassment isn't one act. It's a series of acts that serve no legitimate purpose and cause distress. That's the bar. And once that standard was read aloud, everything that followed was measured against it. Miss Stewart's testimony flipped the narrative. What she described wasn't an overreaction to a noisy vehicle. It was a pattern. Engine revving. Pausing in front of her home. Repeated passes at odd hours. And critically, the catalyst wasn't confrontation. It was a single, non-threatening text message sent to a parent, not even to Wyatt himself. One message expressing concern. No insults. No threats, no demands. That detail mattered. Because harassment law doesn't protect people from being annoyed, it protects them from being targeted. Patrick Johnson's testimony, while passionate, did more harm than good. His defence boiled down to one idea: I believe my son. And emotionally, that's understandable. But legally, it's irrelevant. Courts don't run on parental trust, they run on evidence. Saying unless I have proof otherwise, I'm going to believe my son might make sense at the dinner table, but it collapses under judicial scrutiny. Especially when the proof is video footage played in open court. And that video was the turning point, because once the judge saw it, the debate stopped being hypothetical. This wasn't about exaggeration or hearsay anymore. It was about observable behaviour, a truck lingering, revving, gestures that serve no functional purpose, and most importantly, conduct that reasonably explains why someone would feel unsafe in their own home. The neighbour witness sealed it. Calm, direct, no theatrics, no personal vendetta, just a simple account. This behaviour was noticed, it was repeated, and it escalated after the text message, not before. That timeline mattered more than anyone seemed to realise. And here's the quiet lesson in all of this. Escalation doesn't require yelling. It requires stubbornness. Every chance to de-escalate was ignored. No conversation. No clarification. No attempt to resolve it neighbour to neighbour. Instead, silence turned into assumptions. Assumptions turned into resentment. And resentment turned into intimidation, whether intentional or not. The judge wasn't impressed by outrage. He wasn't swayed by "I don't owe them anything." Because in civil law, especially harassment cases, what you owe isn't courtesy, it's restraint. If your actions cause fear and serve no legitimate purpose, intent becomes secondary. This case didn't explode. It eroded. And that's why it's so important. Because disputes like this don't start with malice. They start with pride. With someone deciding that acknowledging another person's concern feels like surrender. With someone choosing to be right instead of being calm. And by the time it reaches a courtroom, the damage is already done. In the end, this wasn't about who sent a text, who waved first, or who revved louder. It was about accountability. About recognizing that freedom to act ends where intimidation begins. And about understanding that I believe my son is not a legal defense when your behavior affects an entire neighborhood. The real takeaway here isn't who won or lost. It's how easily this could have been avoided. One conversation. One acknowledgement. One decision to disengage instead of double down. Instead, everyone walked out with something heavier than they came in with. A legal record, strained relationships, and the hard lesson that courts don't care how justified you feel, only how you behave. And that's the part most people learn too late.